Welcome to Criminal Law class. This class is on gross negligent manslaughter to understand the key elements, the real world scenarios and the legal controversies surrounding this critical area of criminal law. My name is Nasir Hafizi. I am a solicitor and a senior lecturer. So the learning objectives in this class are to understand the key elements, explain the fundamental elements that constitute gross negligent manslaughter. 2, to understand real-world scenarios, examine practical examples and case studies from medical and other professional contexts. And also to understand some of the legal controversies, explore the debates and criticisms surrounding this area of law of gross negligent manslaughter. As always in these criminal law classes, there's a set of true and false questions. This one is about gross negligent manslaughter. So question 1 is, true or false, gross negligent manslaughter requires proof of intention to kill or cause grievous bodily harm. Question 2, true or false, the case of R versus Adamaco 1995 established the modern test for gross negligent manslaughter. Question 3, true or false, to establish the offence there must be a duty of care owed by the defendant to the victim. Question 4, true or false, a person can only be guilty of gross negligent manslaughter through a positive act, not an omission. Question 5, true or false, in R versus Singh 1999 the Court of Appeal confirmed that the breach must involve a serious and obvious risk of death, not merely injury. Question 6, true or false, the question of whether negligence is gross is a matter of law to be decided by the judge. Question 7, true or false, in R versus Selu 2016 clarified that conduct must be truly exceptionally bad to reach the criminal threshold. Question 8, true or false, in R versus Rose 2018 the Court of Appeal held that foreseeability of death must be assessed based only on what the defendant knew before the breach occurred. Question 9, true or false, professionals such as doctors and electricians can be liable for gross negligent manslaughter when their breach of duty causes death. And question 10, true or false, ordinary negligence, even if serious, is sufficient to amount to gross negligence manslaughter. As always, there's also single best answer questions. So there's 3 here, and as always, there's in these classes the answers are at the end. So the first one, single best answer question 1. Dr. D, an anaesthetist, is monitoring a patient undergoing routine surgery. Midway through the procedure, a key oxygen tube becomes disconnected. A nurse alerts Dr. D to an unusual beeping noise, but D, the defendant, the doctor, ignores it, assuming it to be a minor technical fault. Several minutes pass before D checks the equipment, by which time the patient has suffered cardiac arrest and dies. Expert evidence confirms that a competent anaesthetist would have noticed and corrected the fault immediately. At trial, the prosecution alleges gross negligent manslaughter. Which is the correct legal position? Is it A, the defendant is not guilty because he did not intend to cause harm? Is it B, the defendant is guilty of gross negligent manslaughter because his breach of duty was so gross as to be criminal? Is it C, D is only civilly liable for negligence, not criminally? Is it D, D is guilty only if the hospital procedures were also defective? Is it E, defendant is guilty of unlawful act manslaughter, not gross negligence manslaughter? And then looking at single best answer question 2, defendant and her partner lived with defendant's elderly father, who becomes increasingly ill and bedridden. Over several weeks, the defendant fails to seek medical assistance despite obvious signs of infection and malnutrition. Eventually, the father dies from neglect. Now, which is the correct legal position? Is it A, defendant cannot be guilty because omission cannot constitute gross negligence? Is the answer B, defendant may be guilty if she owed a duty of care and her failure to act was a gross breach that caused death? Is it C, D is guilty only if she intended to cause harm to her father? Is it D, D is not guilty because only professionals can owe a duty of care in gross negligent manslaughter? Or is the answer E, is guilty of manslaughter only if the father consented to her inaction? And then the final single best answer question is here. Defendant is a qualified optometrist. During routine eye examination, defendant fails to examine a child's optic nerve, missing signs of swelling that would have indicated a life-threatening brain condition. The child later dies. Expert evidence shows that if the defendant had conducted a full examination, the risk of death would have been obvious. However, at the time of the consultation, the defendant was unaware of the swelling because she failed to look. Which is the correct legal position? Is it A, defendant is guilty because her failure caused death and was negligent? Is it B, D is guilty because the risk of death would have been obvious if she had examined properly? Is it C, defendant is not guilty because the risk of death must be assessed based on what she actually knew at the time of the breach? Is the answer D, defendant is not guilty because only doctors can be liable for gross negligence manslaughter? Or is the answer E, D is guilty if the jury considers her mistake truly exceptionally bad? And as I've explained, the answers are at the end. So let's now look at what is gross negligent manslaughter, the history of it, the problems in the criminal law, and look at some of the key summary findings as well. So let's look at the legal gap. Now traditionally, manslaughter charges require specific criminal intent. Murder needs intention to cause death or grievous bodily harm, whilst unlawful act manslaughter requires at least recklessness and a positive criminal act. And there's a separate class on those topics of murder and unlawful act manslaughter, so please watch those videos. However, it is said these requirements create difficulties in holding professionals accountable when death occurs through negligence rather than criminal intent. So this is where gross negligence manslaughter comes into place. Now you got scenario 1 as an example. And we're going to return to these scenarios as well. So Dr. Steve's fatal error. Dr. Steve is on duty at the local hospital. He is suffering from a hangover and a lack of sleep after an all-night party. He administers a fatal dose of morphine to a seriously ill patient who dies 3 hours later as a result of the overdose. Dr. Steve claims he misread the instructions regarding the correct dosage. He is devastated by the patient's death, showing no criminal intent. Now look at scenario 2, Dr. Tony's omission. Dr. Tony is a junior doctor working without sleep for 30 hours. He fails to arrange x-rays for a newly admitted patient complaining of severe pains and breathing difficulties. The patient dies of blood poisoning caused by a perforated ulcer. An x-ray would have identified the problem. Immediate treatment could have saved the patient's life. Dr. Tony was exhausted with no one to call for help. So there are a couple of comments to make on these two scenarios and why the traditional framework of criminal law charges would fail. So look at the murder charge. Failure due to lack of mens rea. Neither doctor intended to kill or cause grievous harm to their patient. Let's look at unlawful act manslaughter. Impossible to convict as neither committed a criminally unlawful act. Dr. Steve had consent and Dr. Tony failed to act rather than committing a positive unlawful act. So this is the problem of gross negligence. There's no general criminal liability exists for negligence alone, despite both falling below competent professional standards. So the solution was gross negligence manslaughter. The offence in a way mops up defendants who wouldn't usually expect to be caught by the criminal justice system, including professionals doing their jobs, such as medical practitioners. There are 4 elements to gross negligence manslaughter. There's got to be a duty of care. The defendant owed the victim a duty of care. There's got to be a breach of that duty. The defendant breached that duty. The third element is the causation. The breach caused the defendant the death of the victim. And the final element is gross negligence. Defendant's conduct was grossly negligent. And we're going to look at each of those elements in turn. So let's look at duty of care first. Now, in most cases, determining whether a duty of care exists is straightforward. Well-established duties exist between various parties, and judges will direct juries accordingly. So, for example, patient and child, there's a natural duty of care arising from the parental relationship. Employer and employees, contractual and statutory duties in workplace settings exist. And then there's driver and road users. There's a legal obligation to exercise reasonable care whilst driving. But then it's not so clear in certain situations. So look at this example of creating danger situations, R versus Willoughby 2004. Now, Steve's supplied his friend Tony with heroin. Tony overdosed, but instead of seeking medical assistance, Steve kept him under observation overnight as he was afraid of getting into trouble, and Tony died. Now, the Court of Appeal in R versus Willoughby stated whether a duty of care exists is usually a matter for the jury, and the judge has decided that there is evidence capable of establishing a duty. So in the above example, Steve owed a duty of care because he had created or contributed to a life-threatening state of affairs and ought to have taken reasonable steps to save Tony's life. Let's look at the other element, which is breach of duty, acts and omissions. Please note that the prosecution must prove the defendants breach their duty of care through a positive act, omission or negligent behaviour. So in R versus Carr 1998 confirmed that general principles regarding duties to act apply to gross negligence manslaughter cases. A person can be liable for failing to act, but only where there was a duty to do so. This principle was established in R versus Evans 2009, where a defendant supplied heroin to her half-sister who overdosed, and despite recognising the condition, the defendant chose to not to seek medical assistance. Other examples when duty exists for a failure to act. These are just some examples here. Jackie's negligence, leaves a 16-month-old Harry unattended in a bath for 60 minutes while talking on a telephone. Harry drowns mother and child. There's a duty of care. Joe's professional error. Electrician fails to notice wrong connections despite customer complaints of electric shocks. Kevin dies by electrocution, contractual duty of care. And you got Tony's surgical mistake. A junior surgeon fails to notice a gauze left in a patient's stomach. Patient develops complication and dies. Professional duty of care. It's also important to know when no duty exists. So the example here of where Steve sees a child struggling in a pool. The child is clearly in distress, but Steve, who has never seen the child before, does nothing to help. The child drowns. Steve would not be liable for manslaughter by gross negligence, as he is not under a duty to act to help the child. There is no established relationship or situation that creates a legal obligation. The ordinary principles of negligence applies. A defendant breaches their duty where conduct falls below the expected of a reasonable person with their knowledge and expertise. But note, in that example, no duty exists. Let's look at the third element, which is causation and the risk of death. The defendant breach must have caused the victim's death, applying usual causation rules, that is factual and legal causation tests. And please watch the videos on causation. This aspect rarely causes significant difficulties for juries in practice. Crucially, the breach must involve a risk of death. So in R versus Singh in 1999, the court established that circumstances must show a serious and obvious risk, not merely of injury or even serious injury, but of death. The risk must be present. Smuggling immigrants in a sealed lorry, suffocation risk clearly foreseeable. Risk absent, doctor failing to attend a child with a rare disease, merely possibility is insufficient. So there needs to be a serious and obvious risk, not merely of injury or even serious injury, but of death. The landmark case of R versus Adamaco 1995. Now the facts of this is an anaesthetist during an eye operation failed to notice when a tube became disconnected from a ventilator. The patient suffered cardiac arrest and died. Lord Mackay said this: the jury must consider whether that breach of duty should be characterised as gross negligence and therefore as a crime, whether the extent to which the defendant's conduct departed from the proper standards of care was such that it should be judged criminal. The Adamaco test explains. So Lord Mackay established that ordinary negligence principles apply to determine breach of duty. The crucial question becomes whether the breach should be characterised as gross negligence, deserving of criminal punishment. The test involves an element of circularity, but focuses on whether, having regard to the risk of death involved, the defendant's conduct was so bad in all the circumstances as to amount to a criminal act or omission. This is supremely a jury question requiring assessment of degree rather than precise legal definition. So in the case of R versus Suller, raising the bar, the Court of Appeal in that 2016 case provided further guidance confirming that the test requires conduct that was truly exceptionally bad and was such a departure from the standard of a reasonably competent doctor that it consequently amounted to being criminal. This demonstrates the high bar that prosecutions must reach to succeed in a conviction of gross negligence manslaughter. The conduct must be far beyond ordinary professional negligence, i.e. truly exceptionally bad. And in the case of R versus Rose, now this is important about foreseeability clarification. So in that case, the Court of Appeal allowed an optometrist appeal against her conviction for manslaughter of a 7-year-old boy who died because of her failure to properly examine the back of his eyes. The judges confirmed that in assessing reasonable foreseeability of serious and obvious risk of death, it is not appropriate to take into account what the defendant would have known but for his or her breach of duty. The clarification helps define the boundaries of when the risk of death test is satisfied. So applying the law to Dr. Steve and Dr. Tony, those two scenarios we started off with, both doctors clearly owe duties of care to their patients and have breached those duties, causing death with risk of death present. The determining factor is whether the jury considers the breach amounts to gross negligence. Is the conduct so bad in all the circumstances that it amounts to a criminal act or omission? So in Dr. Steve, hungover doctor administrating fatal morphine dose, likely to be seen as gross negligence given the obvious risk. And then in Dr. Tony's case, exhausted junior doctor failing to order x-rays. Jurors may have differing views on whether this reaches the criminal threshold. So I want to end by talking about the key criticism and controversies about gross negligence manslaughter, because it has faced some significant criticisms, particularly regarding determining what constitutes as gross negligence. So there are three potential criticisms here. One is about the circular reasoning. The test involves determining if negligence is criminal by asking if it's criminal without clear guidance acknowledged but accepted by the courts. There's also jury, therefore, inconsistencies. Different juries may reach different conclusions on identical facts, creating uncertainty for professionals. And I think the final criticism is about professional fear. Risk of criminalising honest mistakes may lead to defensive practice in medicine and other professionals. So now going back to these true and false questions, please feel free to pause this video, find out and identify what your answer would be, and check with the next slide whether you got it right. This is the next slide. Hopefully you got the answers right there to test whether you, and it's got an explanation there too. Look at the next slide, which is the single best answer questions. This is question 1 and question 2. Check what your answer would be with the next slide. And this is the next slide, and there's some brief explanation there too. Then final single best answer question, which is single best answer question 3. Check what your answer would be with the next slide. Feel free to pause the video too. And then look at this question here, question 3, foreseeability of death, R versus Rose. That's where the answer comes from. And just look at the correct answer. In R versus Rose, the Court of Appeal held that the obvious risk of death must be assessed based on what the defendant actually knew at the time of the breach, not what they would have known if they have acted competently. So just by way of summary, to establish gross negligence manslaughter, prosecutions must prove all elements beyond reasonable doubt. So remember, there are these basically 4 of 5 elements. So you've got a duty of care, clear and established duty owed by the defendant to the victim. The second one is breach of the duty through act or omission falling below reasonable standards. Part of that is that it's got to be a risk of death. Serious and obvious risk of death must be foreseeable. It's got to be causation. Breach must have caused the victim's death. And the final one is gross negligence, conduct so bad as to deserve criminal punishment, the crucial test. Remember, ordinary negligence insufficient for criminal liability, no need to prove intention or recklessness, defendants punished for their negligence alone. I hope you found that this class useful. If you haven't already, please like the video, please subscribe to the class, and I hope you found this class, and please join me in the next class, which is on unlawful act manslaughter.